Nighttime stories like this rarely begin with sirens or headlines. They begin with small deviations that look harmless until someone finally stops pretending not to see them. A private flight here, a security detail where none is warranted, a procedural excuse that sounds technical enough to discourage questions. And this is where the main thing begins, because power doesn't usually collapse under pressure. It slips when routine lies stop matching the paperwork. Over the past weeks, Washington has been quietly circulating a rumor that refuses to go away. The position of FBI director may soon be vacant. Not because of elections, not because of policy disagreements, but because the man occupying that office has become a liability. Kash Patel has been generating the kind of attention that institutions fear most. Attention that is petty on the surface and existential underneath. Personal trips on government aircraft. Tactical units assigned for reasons no one can explain on record. Individually, these things look like bad judgment. Together, they suggest entitlement. And entitlement is usually the last stage before exposure. What almost no one expected was how abruptly the situation would accelerate. In a federal courtroom, without cameras or speeches, a judge interrupted the performance. James Boasberg did not accuse, he verified. He compared statements to records, claims to dockets, explanations to orders that should have existed if any of it were true. They didn't. And once that became clear, the tone changed. Not politically, legally. The core of the conflict is deceptively simple. Congress demanded access to a specific set of documents tied to one of the most toxic investigations in modern American history. The evidence archive connected to Jeffrey Epstein. As FBI Director, Patel controls access to those materials. For months, he insisted he could not comply. He told lawmakers and courts the same story. Sealed judicial orders prohibited disclosure. Active cases, legal firewalls, non-negotiable constraints. It sounded plausible because it always does. Courts seal things all the time. That is how bureaucratic lies survive, by borrowing the vocabulary of legitimate caution. But they usually keep quiet about one thing. Judges talk to each other, and when a claim about sealed orders reaches a judge who never signed one, the illusion collapses fast. Boasberg checked, not selectively, completely. He reviewed sealed dockets, cross-referenced jurisdictions, consulted colleagues. Nothing matched Patel's statements, no orders, no restrictions, no legal barrier at all. What remained was the implication no official wants to face. The obstruction wasn't passive, it was constructed. In that courtroom, the question stopped being whether the documents would be released. It became whether the FBI director had committed perjury, whether invoking fictional court orders to block subpoenas qualifies as criminal contempt, whether a senior law enforcement official can lie to Congress and the judiciary and continue as if the system will absorb it. The judge's answer was not theoretical, it was immediate. Comply by the end of the day or be taken into custody. Observers describe a moment of stillness that felt unnatural. Patel did not argue. He did not clarify. He did not negotiate. He stood there while his legal team whispered and recalculated because everyone understood the trap at the same time. Turning over the files would not end the story. It would start another one. A story about who ordered deletions, who approved concealment, and why certain images vanished from public record. Refusing would mean jail. Not symbolic consequences. Physical detention. Now. This is not happening in isolation. The Epstein archive has already left collateral damage. Pam Bondi has faced scrutiny over the removal of sensitive material from an official evidence repository. Images reportedly showing proximity between Epstein and powerful figures, including Donald Trump. Congress wants to know who gave that order. Patel knows. Or at least he knows where the answer is stored. That is why the delay mattered. That is why the excuse had to sound legal. And that is why the judge stopped tolerating it. Here is the uncomfortable truth that hangs in the air. No one risks immediate incarceration over documents that are harmless. No one invents judicial barriers unless what lies behind them changes the balance of power. And now, with hours instead of weeks, the system has forced a decision that cannot be undone once made. One choice reveals what has been hidden. The other proves it was worth hiding. From that moment, everything narrowed to mechanics. Not politics, not loyalty, procedure. Because once a court establishes that a senior official fabricated legal obstacles, the system no longer negotiates narratives. It enforces consequences. The first layer is simple and brutal. A claim about sealed orders is not an opinion. It is a factual assertion that can be verified in minutes. When such orders do not exist, the statement becomes something else entirely, a false representation of judicial authority. That alone satisfies the threshold for obstruction because it weaponizes the court's name to defeat lawful oversight. And when that statement was repeated under oath, in formal testimony, the legal classification hardens. It stops being spin. It becomes perjury. This is why the judge's language mattered. He did not warn, he instructed. Criminal contempt is not leverage designed to force compliance later. It is a declaration that the offense has already occurred. Civil contempt pressures you until you obey. Criminal contempt punishes you because you already crossed the line. By invoking it, the court signaled that even full cooperation might no longer erase liability. The clock was not about avoiding guilt. It was about limiting damage. What makes this moment more dangerous than it appears is what those files represent institutionally. The Epstein archive is not a single case file, not a closed investigation, not a historical appendix that can be managed with redactions and press language. It is a map, a structural map of access, movement, money, and silence. Flight logs don't just show where a plane went, they establish patterns of behavior over years. Financial transfers don't just move funds. They draw lines between people who claim they never intersected. Photographs don't simply capture moments. They establish proximity at specific places and times that later statements must account for. Internal communications do something even more corrosive. They establish intent. They show what people knew, when they knew it, and how they chose to respond. When evidence of that density is selectively withheld, the damage is not cosmetic. It does not merely distort public perception. It reshapes prosecutorial reality. Investigations are not guided by suspicion alone. They are guided by what is visible and admissible. Cases are opened or quietly abandoned based on whether evidence appears complete or fragmented. Remove enough connective tissue and accountability doesn't fail loudly. It becomes statistically impossible. The absence of evidence begins to look like the absence of wrongdoing, and the system moves on under false assumptions it can never correct retroactively. The deletions already acknowledged raise questions that go far beyond embarrassment or political inconvenience. They force a chain of command analysis the system cannot ignore. Who identified the material for removal? Under what authority that decision was justified? Whether any written rationale exists. Whether legal standards were cited honestly or retrofitted after the fact. Whether the stated justification, victim protection, aligns with what was actually erased, or whether that explanation functioned as a moral shield for something far more transactional. And, most critically, whether coordination occurred between political offices and law enforcement leadership to manage exposure rather than evidence. If communications exist that show deliberate filtering, timing adjustments, or selective preservation, that is no longer administrative discretion. That is conspiracy to obstruct, regardless of how carefully it was framed at the time. This is where the risk escalates for everyone involved, including those who believed distance would protect them. Once documents are produced under court order, control evaporates immediately. They are logged, duplicated, preserved across systems designed specifically to prevent quiet revision. Metadata becomes as important as content. Whistleblowers gain reference points instead of impressions. Investigators can triangulate testimony against timestamps, deletions against access logs, explanations against internal debates that were never meant to surface. Discrepancies don't get resolved, they multiply. The narrative stops being about one official's refusal and becomes about a system that assumed it could curate reality indefinitely without triggering, jurisdictional consequences. There is also a structural irony here that no one inside the building can ignore. The FBI director is not accustomed to being compelled. The role is constructed around authority, issuing demands, enforcing compliance, defining thresholds. But courts do not operate on hierarchy. They operate on jurisdiction. In that room, rank did not matter. Titles did not matter. Political context did not matter. Only compliance did. And that reversal, at the moment power meets its limit without negotiation, is almost always when procedural shortcuts and narrative scaffolding begin to fail under scrutiny. Even if the documents are released in full, the legal exposure does not end. False statements to Congress do not retroactively become misunderstandings. A referral to prosecutors does not dissolve because cooperation arrived late. Perjury does not convert into miscommunication once evidence appears. At best, compliance alters the sentencing calculus. It does not erase the record. It does not undo sworn testimony. It does not reconstruct credibility once it has been formally disassembled in a courtroom. This is why the broader implications are already being discussed quietly, away from microphones and press releases. Obstruction of justice is not an abstract phrase. It is one of the few offenses that instantly converts individual misconduct into institutional crisis. It implies intent to shield others rather than correct error. It invites scrutiny upward instead of inward. It allows lawmakers to argue, with evidentiary grounding rather than rhetoric, that misconduct was not accidental, isolated, or personal, but coordinated and protective by design. The most revealing aspect of this episode is not the threat of arrest itself. It is the silence that followed it. No immediate denials calibrated for plausibility. No confident rebuttals asserting misunderstanding. No paperwork rushed forward to manufacture clarification. Silence in moments like this is not strategic. It is diagnostic. It means every available explanation has already been tested internally and found insufficient to withstand record comparison. What happens next does not hinge on public reaction or narrative control. It hinges on what is inside those files, how quickly they are surrendered, and how completely the earlier story collapses once documents are examined side by side with sworn testimony. That comparison is where careers end, not with spectacle, with alignment, and this is why the situation remains unresolved in the most unsettling way. One decision still determines the shape of everything that follows. Release confirms what was hidden. Refusal confirms why. The system no longer cares which path is chosen. It has already moved past persuasion. It is waiting for proof. There is one more layer here that is rarely discussed openly, but everyone inside the system understands it. Once a court forces disclosure in a case like this, the precedent becomes as dangerous as the content. It tells every other agency head, every political appointee, every senior official sitting on sensitive material, that fabricated legal barriers will not be tolerated as a delaying tactic. That matters because delay has become the preferred weapon of modern obstruction. Not outright refusal, not dramatic defiance, but procedural fog. Enough time passes, interest fades, elections intervene, priorities shift. This case interrupts that logic. It also exposes a miscalculation that appears repeatedly in high-level cover-ups. The belief that oversight bodies operate in isolation. Congress is assumed to be political. Courts are assumed to be procedural. Prosecutors are assumed to be cautious. The mistake is thinking these lanes never intersect. In reality, they converge precisely when sworn statements collide with records. That collision is what triggers escalation, and once it happens, institutional self-preservation gives way to institutional correction. Another overlooked consequence is internal. Agencies are not monoliths. When leadership is exposed as having misrepresented legal constraints, it destabilizes everything beneath them. Career officials begin documenting conversations. Compliance officers start preserving drafts. Legal counsel recalculates exposure. Silence inside the building breaks not with leaks, but with memos. And those memos tend to outlast any single individual. There is also the question of timing, which is never accidental. Evidence management decisions made years earlier are now being evaluated under a different political and judicial climate. What once felt containable now looks reckless. Actions taken under the assumption of permanent alignment between political power and institutional protection are suddenly being reclassified as personal risk. That shift is why cooperation, when it comes, often comes late and incomplete, because the realization arrives after the window for clean exit has closed. And finally, there is the quiet recognition that this moment cannot be undone by narrative control. No reframing can erase sworn testimony. No counter-allegation neutralizes documentary contradiction. Once files are produced, they exist independently of explanation. They speak in timestamps, signatures, access logs, and chains of custody. They do not argue, they align or they don't. They align or this is why the tension does not dissipate even after deadlines pass. The real reckoning begins not with compliance, but with comparison. What was said versus what exists. What was claimed versus what was done. That gap, once visible, it does not close. It widens. And everyone involved understands that the most damaging phase of this story does not arrive with arrest threats or courtroom exchanges, but with the slow, methodical reconstruction of truth from records that were never supposed to be read together. At that point, the question is no longer who made the decision. It becomes who knew it couldn't survive scrutiny, and acted anyway.